This is Syndication Attorney Field Notes. I'm Tilden Moschetti, a syndication attorney, and today's field note is about blue sky laws in a Rule 506 Regulation D private placement. Here's the scenario I keep seeing. A sponsor files the Form D with the SEC, they hear the word preemption, and they conclude the states have nothing left to say. That's the mistake. So let me give you the direct answer first. Rule 506 exempts your private placement from full state registration. It does not exempt you from the states entirely. You still have to file notices and pay fees in the states where your investors live. And states keep their power to investigate fraud, no matter how clean your federal paperwork looks. If you take one thing from this episode, take that. The rest is just how it actually works. Let me talk about why the mistake is so tempting. The word preemption sounds broad. It sounds like a force field. And when a sponsor hears that federal law preempts state registration, it's easy to fill in the rest and assume the states are gone completely. But federal preemption is a shield against state registration. It is not a cloak of invisibility. The states can still require notice filings, they can still collect fees, and they can still investigate fraud. That's not a state getting aggressive. It's written right into the federal law that created the preemption in the first place. So a federal Form D does not clear your state obligations. It's the starting point, not the finish line. Now here's the distinction that really matters, and I want you to slow down with me here. There are two very different things a state can ask of you. One is heavy, one is light. Rule 506 lets you skip the heavy one, but you still owe the light one. The heavy one is full state registration. In some states, that can involve what's called a merit review. That means a regulator doesn't just check whether your disclosures are complete. They actually judge whether the deal is fair to investors. A state official could look at your terms and decide they're too rich for the sponsor or too risky for the investors and hold things up on that basis. Now imagine doing that in every state where an investor lives, dozens of regulators, each on their own schedule. A multi-state raise would be almost impossible. That's the burden Rule 506 removes. The light one is a notice filing. And a notice filing is exactly what it sounds like. It's a notification, not a request for permission. You're telling the state, a federally exempt offering happened here. Here's a copy of my Form D, and here's your fee. Think of it like a toll booth you're allowed on the highway. You still log your entry and pay the toll. So remember this framing. You are not seeking approval. You are keeping records and paying tolls. Okay, next practical question. Whose blue sky laws apply to your raise? This one surprises people. The answer generally follows the investor, not the sponsor and not the property. Let me give you a quick example. Say you're a sponsor based in Texas. You're buying a property in Florida, and your investors are in California and New York. Which states' notice rules come into play? Generally, the states where the investors live. So in this example, that's California and New York. The Florida property location usually doesn't drive that analysis at all. Your home state still matters too. You'll typically also file where you run your business and where your entity was formed. So you might be looking at the investor states plus Texas, depending on the facts. The point is this. The geographic question isn't, where's my deal? It's, where's my money coming from? And once you scale that up to a fund with investors in 15 or 20 states, this stops being a hard legal question and becomes a logistics question. Every state has its own fee schedule, its own portal or the shared filing system, and its own small quirks. There's no single national filing that clears all of them at once. One more operational note. Your federal Form D is generally due within 15 days of the first date of sale. The first date of sale is usually the moment your first investor is irrevocably committed. Think signed subscription docs and a funded wire. And that Form D is your master document. The data you enter federally feeds your state filings. So if the federal form is wrong, those errors tend to spread into every state filing built on top of it. Now, here's the part that separates the sponsors who really understand this from the ones who think a clean Form D is a force field. Preemption stops state registration. It does not stop fraud enforcement. Filing your Form D perfectly does not buy you permission to mislead investors. A state securities regulator can still investigate a covered offering. So I'm federally exempt is not an answer to a fraud inquiry. It was never meant to be one. And here's where this shows up that most sponsors don't expect. It's often not about lying about the property or the returns. It's about how the money got raised and who got paid to raise it. States pay real attention to sponsors who pay transaction-based compensation to unregistered people. That's the classic finder's fee problem. If someone gets paid only when investor money comes in, that payment can raise a broker-dealer question, and a state can decide to look at that, depending on the facts, no matter how clean your federal exemption is. So the federal shield covers registration. It does not neutralize a state's power to look at how the deal was actually raised. Let me leave you with the field note. For a Rule 506 syndication, blue sky laws are not a permission system. Don't treat them that way. Treat them as a filing map and an enforcement backstop. Rule 506 preempts state registration. It does not preempt notice filings or fees. Investor residency usually drives the map alongside your home state and your entity's formation state. The 15-day federal clock is your baseline, and the Form D is the master document everything else is built on. And state anti-fraud power never went away, including how you raise the money. The sponsors who get surprised aren't the ones who studied the history. They're the ones who assumed a federal exemption meant the states had nothing left to say. Now you know they do, and you know where. The longer written version of this is in the show notes. I'm Tilden Moschetti, and that's today's Field Note.